All right, today we are going to crack open one of the biggest, most important rules in all of law. Seriously, it's a rule that basically decides what a judge or a jury is even allowed to hear in a courtroom. It's called the hearsay rule, and trust me, it's way more interesting than it sounds.
So, why is that classic he said, she said stuff almost always banned in court? I mean, that's the real question here, isn't it? It all boils down to this. The legal system is super skeptical of secondhand info. You know, gossip, rumors, it's built this massive wall to keep all of that out of a trial.
Okay, so let's get into it. Here's the plan for today. We're going to start with the main rule, which I like to call the hearsay gatekeeper. Then we'll talk about the business records master key that gets around it. We'll also see when that key gets blocked, check out a whole keychain of other cool exceptions, and finally, we'll wrap it all up with the big picture.
All right, first up, the hearsay gatekeeper. The best way to think about this rule is like a super strict bouncer standing at the courthouse door, and its only job, its entire purpose, is to stop unreliable gossip and chatter from getting inside and messing up a trial.
Okay, so there's the fancy legal definition, but what does that actually mean? Well, it means a witness can't just hop on the stand and say, "Oh yeah, my neighbor told me the getaway car was blue," if you're trying to prove the car was in fact blue. No way. The court wants to hear it straight from the horse's mouth, from the neighbor who actually saw the car. It's all about reliability, right? And giving the lawyers a chance to question the person who made the original statement. But here's the catch. What if that gossip isn't really gossip at all? What if it's a super reliable documented record? You know, like a detailed hospital chart, or a police report, or a standard company invoice. Suddenly, our gatekeeper seems a little too strict, doesn't it? It's blocking perfectly good, sometimes even crucial evidence. And that, my friends, is exactly why the law came up with a whole set of keys to unlock that gate. And now we get to the master key, the most powerful key of them all. It's known as the business records exception. And you know, the source material we're looking at calls this one of the most successful legal reforms ever in evidence law. And for very good reason. It unlocks the door for some incredibly important information to get into a trial. So how do you use this key? Well, getting a business record into court comes down to a really simple but powerful three-step test. First, is it actually a business record? We'll get to what business means in a sec. Second, was it made by someone who actually knew what they were talking about, someone with personal knowledge? Or third, was it based on info from someone with personal knowledge? See the pattern? It all tracks back to a reliable first-hand source.
And when the law says business, you might be surprised at how broad that definition is. We're not just talking about your typical for-profit company. It includes police forces, hospitals, government agencies, even royal commissions. Why? Because the law doesn't really care about profit. What it cares about is this: was this record made as part of a regular, routine, day-to-day activity? It's that routine that makes it trustworthy.
And here's where it gets really practical. The courts have a lot of flexibility here. You don't always need to drag the person who wrote the record into court to swear, "Yep, that's my handwriting." If a mechanic's invoice looks totally legit and was made in the normal course of things, a judge can just infer that it's reliable. The law gets that it's the system of record keeping that creates the trust, not necessarily one specific person. But hold on a second. This master key isn't a skeleton key that opens every lock. There's a huge catch, a big exception to the exception, where that courthouse door slams shut again even if you're holding what looks like a perfect business record. And here is the bright red line. Let's say you have a routine doctor's note, just part of regular patient care. That's in. But what if that same doctor writes a special report, specifically for a lawyer to use in a lawsuit? That's out. And the reason is simple. The law worries that once a lawsuit is in the picture, the motivation might shift from just being accurate to trying to win the case. So what does "in contemplation of a lawsuit" actually mean? Well, it's a pretty high bar. It's not just some vague one-in-a-million chance that someone might sue someday. It means that when the document was being written, legal action was seen as likely or reasonably probable. That's the specific trigger. Once you cross that line, the business record exception gets blocked. Okay, so we've talked about the master key, but what about the rest of the keychain? The law has a whole bunch of other smaller, more specialized keys for letting in specific types of hearsay. Let's do a quick lightning round on a few of the most useful ones for our modern world. These are just so practical. It's great. First, you have one for tags and labels. That means the writing on a shipping label that says what's inside a box, that's allowed in. Then there's one for electronic messages. This is huge. It means the to, from, and date sent lines on an email are basically taken as fact. You can imagine how much time that saves in court.
All right, let's switch gears a bit. The law is smart enough to know that not all truths are written down in a business ledger. Some truths are just known by a family, by a community, or through long-standing tradition. And that's where evidence based on reputation comes into play.
This is really about the law recognizing there are different ways of knowing things. I mean, think about it. How do you prove your great-grandparents were married if the records are gone? You do it through family reputation. How do you prove a path has been a public right-of-way for 100 years? Through community reputation. And this is so important. This same idea provides a pathway for evidence about the traditional laws and customs of Aboriginal and Torres Strait Islander groups.
Okay, we've looked at the main gatekeeper role, the master key, the whole keychain of exceptions. But what's the big idea here? What's the thread that ties all of this together?
So let's zoom out and look at the big picture, because this isn't just a random pile of complicated rules. There's a really clear core philosophy driving the whole thing.
And here it is, it all comes down to a balancing act. The entire Hearsay system is basically a giant tug of war. On one side, you have the need to protect the trial from bogus rumors and gossip, and on the other side, you have the need to make sure good, solid, trustworthy evidence actually gets in front of the jury. It's all about finding that balance in the search for truth.
And this really shows why these exceptions are so vital. I mean, ask yourself, what do you think is more reliable? A doctor trying to remember the details of a routine checkup from 3 years ago, or the detailed notes they typed into their computer at the exact time of the appointment? Right. As the source material says, a business record made before anyone was even thinking about a lawsuit is often much more accurate than any oral evidence. Sometimes the document is just plain the best evidence we've got.
So the next time you're watching a movie or a TV show with a courtroom scene, and you see a lawyer dramatically introduce a document, you'll know what to look for. Is that a business record? Is that their key to unlock the hearsay gate? Hopefully, you now have a brand new lens to see how the search for truth really works in the courtroom.